Good morning. A million apologies for the delay. We have São Paulo with us, Fundação Getúlio Vargas in São Paulo with us. We are still trying to figure out how to put the image that we see in the control room right here. They are seeing us right now. So we'll start and I'll have a little introduction and explain to you how are we going to proceed. First of all, welcome to the Institute for this event that is done in partnership with Fundação Getúlio Vargas Law School, DIREITO GV, and the American University Washington College of Law. Special welcome to colleagues and friends from Fundação Getúlio Vargas that are in São Paulo, have joined us by sound right now. And very shortly, I hope also you see the image. We are here today to talk about the meaning and implication of the Mensalão. Obviously, there are more negative opinions than that in Brazil, and there has been actually exchange of opinions through the media, including with sitting members of the Supreme Court. The way we are going to proceed here is, first I would like to introduce our speakers. Oscar Villena is the Dean of the Getúlio Vargas Law School. Previously, he founded and served as co-director of Conecta's Human Rights. He taught constitutional law and human rights at the School of Law Getúlio Vargas and the Catholic University of São Paulo. He served as a state attorney and as executive secretary of the United Nations Latin American Institute in Brazil. You have the full bios. You can read those for benefit of time here. I will read just a few lines of each bio. Then we have the honor to have with us Peter Massetti, Senior United States District Judge for the District of Maryland. A dear friend, Judge Massetti received his bachelor's degree cum laude from Amherst College in 1963. He holds a law degree from the University of Chicago. I think his connection and love for Brazil started when he and his wife Susan served as Peace Corps volunteers in Brazil in the 60s, and he has been since being a connector between Brazil and the United States, the judiciaries of both countries. Actually, we like to refer to Judge Peter Massetti as Juiz de Fora, because he is our Juiz de Fora. Then I would like to introduce Judge Marcelo Costanário Cavalli. He's a federal judge in Brazil, like Judge Peter Massetti. He is a young judge, having received his law degree in 2002 from the Federal University of Paraná, where he his studies focused on accounting and finance. He specialized in economic criminal law at the University of Coimbra, Portugal, where he obtained a Master's of Science in Legal and Economic Studies. We have, last but not least, the pleasure to welcome Professor Matthew Taylor, another dear friend of mine and of the Wilson Center. Matthew's research and teaching include corruption and organized crime, judicial politics, and Latin American political economy. He has lived and worked extensively in Brazil, most recently as an assistant professor at the University of São Paulo. Taylor is the author of Judging Policy, Courts and Policy Reform in Democratic Brazil, which was awarded the Brazilian Political Science Association's Victor Nunes Leal Prize for Best. And more to the point of today's discussion, he is the co-editor with Timothy Power of Corruption and Democracy in Brazil. A Struggle for Accountability was published 3 years ago by the University of Notre Dame Press. With that, I would like to invite speakers to start their brief presentations. We are going to start with 10-minute presentations by each of the speakers and then open up for questions and comments. Dean Oscar Villena will start us off, followed by Judge Peter Massetti, who will be followed by Judge Marcelo, and then Professor Matthew Taylor. With that, I would like to invite Oscar Villena to make his presentation. Thank you.
Okay, Paulo, good morning. My colleagues on the bench there, it's a pleasure to be with you. Since you're not having the image, perhaps we could be more expedient in terms of speaking, not 10 minutes, but perhaps 5, so it will be less boring for you to hear us. So, what is the Mensalão? The Mensalão is a corruption scandal that involved several important members of the government, of the Brazilian government, in the beginning of this decade, or the last decade, that were bribing charged of bribing members of parliament to vote in favor of the government. Because several members of the parliament were involved, this case has original jurisdiction at the Brazilian Supreme Court. So this is a constitutional disposition that when members of parliament are involved, cases should be tried, criminal cases should be tried at the level of the Supreme Court as original jurisdiction. And then you have a court with no appeals to a different court. So this was one of the problems since the beginning of the case. The interesting aspect here is that the Brazilian Supreme Court, the Brazilian Constitution, has a specific clause that says that when members of parliament are involved in criminal cases, these cases should be tried originally by the Supreme Court. So that is the reason why this enormous case involving around 40 people was tried at the level of the Brazilian Supreme Court. So this is the first point that I would like to make. The second interesting aspect that is extremely different than what would be happening in the United States is that the Brazilian Supreme Court decides in public. It's not an in-camera decision, but in public decision. We have 11 members at the Supreme Court, and they work not just in public, but these sessions are televised to the whole country. So, and this is not happening only in this case. This is happening since 1993, when there was a first decision of the Supreme Court to allow television inside of the court, and today we have public television doing this. So you can imagine what was the consequences of this. The country started to follow this trial that had 60 sessions in its first part. The court would meet 3 times a week. So for a long period of time, every day you would have at the Supreme Court the debates around the case. The third aspect that I would like to mention is that this is not a normal case to be tried at the Supreme Court, even though it was there in its jurisdiction. There was a problem because the Constitution asked or obliged that both cameras of the Congress would allow for a trial at the Supreme Court, but this was amended. So since then, the cases could arrive directly at the Supreme Court. So this is the first time in these 25 years of the new Constitution that, in fact, we have a large criminal case of corruption involving higher ranking authorities before the Supreme Court in this long trial. The result after these 60 sessions was that 25 people were found guilty, but 12 of them by a very divided court. Okay, so there was not a majority that would obtain a certain level. So there was a doubt if there were more than 4 dissenting votes, if there was a possibility of a new appeal, a motion for reconsideration, a motion for hearing this case. So in the last week, we had a decision of the Supreme Court that yes, these 12 defendants that were not found guilty by a supermajority, they do have the right to ask for a reconsideration of their cases. And in some way, this decision caused a very public outcry in the sense that this will be another case that where Brazilian authorities will not be tried until the end. But in fact, there is a debate if this was a right, not in the Constitution, but in the bylaws of the court. Is a very obsolete disposition at these bylaws, but it should take place in this case. So today, the legal community in Brazil is very divided about it, even though the public has a perception that this is a problem. So I will end at this point, and we perhaps could debate a little bit more some aspects in the questions.
Thank you very much. I'll invite now Judge Peter Massetti to make his presentation, his initial presentation.
Thank you, Paulo. An interesting introduction by Professor Villena, and I want to comment on it to some extent compared with how issues like this might arise in the United States. First of all, let's be clear about what's going on in Brazil. Nobody is asking at this point to be exonerated totally from criminal responsibility. There's a narrow issue before the court, the Supreme Federal Tribunal right now, and that is whether, and for the most part, there should be some sort of rehearing with regard to what they call formação de quadrilha, which is very much like the conspiracy charge in the United States. Under Article 288 of the Brazilian Criminal Code, 3 people associating together to commit a crime are guilty of a violation. In the United States, the conspiracy law, either at the federal or state levels, if 2 or more people join to commit an unlawful act or to commit a lawful act by unlawful means, that's conspiracy. So it's a comparable idea. And that is what's being challenged. As far as some of the active bribery convictions, they're not before the court. These gentlemen are going to do time one way or another. The question really is, are they going to be in a closed setting with a longer term, or are they going to be in what's called a semi-open, semi-aberto situation where they would work, for example, in work camps and so on and so forth, not to go home on weekends and during the week. They would still be required to serve time and less time, but not in the hard time, if you will, of a prison. So that's really what's going on. The convictions, if you will stay. So insofar as one wants to observe that there are convictions that are solid, there will be punity at some point, whether it's as extensive as perhaps one wants. That's the first proposition. The interesting parallels, of course, the United States Supreme Court has no criminal jurisdiction. This is an original jurisdiction case, bear in mind. This is a case where essentially the trial court is the Supreme Court, the Supreme Federal Tribunal. There hasn't been any sort of appeal taken from a lower court decision of guilt. This is being heard in the Supreme Federal Tribunal. And of course, Americans may wonder, well, what is that all about? Well, why do you have a case being heard originally in the Supreme Court? Because we don't have that kind of original jurisdiction. This is a result of what in Brazil is known as foro privilegiado, or privileged forum. The idea being, and this goes way back to the early times of Brazil, that certain high-level political people can be tried in special courts, only higher courts. And the idea is they should not be tried by ordinary justice the way ordinary people are. People of a higher level, including the president or certain officials, either get tried by the Supreme Federal Tribunal or the Superior Tribunal of Justice, or in the case of, for example, mayors, by the state tribunals of justice. So it's an interesting concept which we don't have in the United States. In the United States, if you are the President of the United States, or more particularly in my experience, the Vice President, you get tried in the United States District Court, the kind of court that I sit in. It happens to be in Maryland that Spiro Agnew got tried for bribery, the District Court. There might be appeals that follow. The point is they are subject, these high political folks, to ordinary justice in our system. The concept of privileged forum in Brazil has been much criticized by many people over a long period of time. I won't get into all that, but it's a very different kind of institution, if you will, that you have to bear in mind as you appreciate what's going on. Now, having said that, if you look at the Supreme Federal Tribunal as essentially a court of first instance here, the real issue, as I see it, is should there be a second look at the decision that they have? Now think about it, just step back for a moment and look at our system, or other systems around the world. You have courts of first instance that make decisions, and you have appeals to higher courts that can then consider whether there was an error of law in the lower court, something that was missed significantly, and so on, an argument that perhaps wasn't fairly made. And you have the second level of judges who are looking at the case a second time, the second look concept. It's always been true in the common law system, the Anglo-American system, and even the continental systems that you can always ask the court, particularly in first instance, will you reconsider? Will you rehear this? There's something that's happened. Now, actually, the United States Supreme Court has done this very, very rarely, I might say, but they do it. There are situations where it has been deemed that perhaps a piece of evidence was overlooked, a rule was misapplied, the court decided to hear re-argument and then issued an opinion that was contrary to the earlier opinion. It's very rare, but the concept of a rehearing is not rare. And particularly remember, this is not so much an appeal. This is really the court that has offered the first opinion, looking at it a second time. Now, of course, what's interesting, just to sort of go back, there are different kinds of appeals in Brazil. The first one was the embargo de declaração, the idea of looking to see whether there was some omission or contradiction or something like that, ambiguity that needed to be cleared up. All of these defendants in this case asked for these embargos de declaração. They were all rejected. So for starters, the court feels, and more or less unanimously, there were a few, I think, which were not unanimous, but the court felt, the ministers, that there were no omissions and ambiguities in the original decision. This idea of embargos infringentes, which is really sort of to see whether it really opens up the reappreciation of the whole case. It's really a reappreciation. Is somewhat novel in the Brazilian system. But here's what's interesting. It does exist in all other courts in Brazil, with the exception, I think, of the Superior Tribunal of Justice. But in lower criminal courts, the idea of going back and sort of seeing, having a second look on infringentes is, as I understand it, possible in Brazil. So in a sense, are you saying, well, it should not be available to a trial court which is hearing a case such as the Supreme Federal Tribunal in this case? A valid question as to whether they should look at it again. Now, what's the kicker, as we say in English? Well, you got two new members of the Supreme Federal Tribunal since the last vote. You've got Minister Barroso and Minister Zavascki, and who knows where they're going to go. That's the issue, and the vote could change. I would say this, I mean, bear in mind, all you got as the decision before the Supreme Federal Tribunal now is the decision to reconsider. It's not actually reconsidering and voting to acquit, to exonerate anybody. All they're saying is, let's listen. And I think, for example, and we don't know how they're going to vote. And when you've granted these embargos infringentes, this review, it's wide open. You can reconsider and you could have a vote. I would say, though, when I was talking about having read Minister Celso de Mello's opinion with regard to the infringentes, it's not clear that he's going to vote to exonerate these people in any way. All he said is, I think I'm obliged to look at this again. And candidly, I mean, I'm not a Brazilian lawyer, but I do read the law, and I think he's probably right. I mean, I think that you have to argue. It's a very narrow legal question in my view as I see the Brazilian situation. There was an internal regulation, a bylaw of the Supreme Federal Tribunal that said that there were these embargos infringentes. And then there was some legislation which some of the ministers said implicitly overruled that, and others said, no, it didn't. And that's a legal issue that I don't know one can get into. Anyway, the Supremo has the issue before it right now, and you don't know necessarily what the outcome would be. So I think one has to watch very carefully as to where the Supremo goes. Number one, there are convictions that are going to stay one way or another. And number two, you may still find that the majority upholds the conviction with regard to the formation of the gang, as they say, the conspiracy, formação de quadrilha. That's entirely possible. So that is the way I see the issue, and it's not unreasonable. This is a very law-minded court, in my view. These are thoughtful people. I would leave, I suppose, end with one question to you, and then make an observation about parallel. Minister Dias-Toffoli was the general counsel of the Workers' Party. He managed President Lula's 3 campaigns for President 3, in fact, 2 successful. He was advocate general of the union, which is like our solicitor general. And a lot of people that he was allied with on a regular basis are among the people making these appeals. Question, should he recuse himself? Should he be in this case at all? Should he be making this decision? Now, we have a law in the United States that applies to our Supreme Court that anybody whose impartiality might be questioned should not sit in the case. Having said that, our members of the Supreme Court can decide whatever they want to for themselves. And recently, with regard to affordable care, the Affordable Care Act, which is probably at the heart of our shutdown of the government right now, but when the issue went before the Supreme Court, some people said, well, Justice Kagan was Solicitor General of the United States when affordable care was enacted. She shouldn't sit. And other people said on the right, but Justice Thomas's wife's been going all over the country talking against the Health Care Act. Why should he sit? And the answer was they both sat because they decided that they could be impartial. So even though one might raise a question about the Minister Dias-Toffoli, and one vote may make a difference in this whole business, he has sat, he will sit, and that's, I suppose, the stuff for historians and political scientists like Matt Taylor to talk about in the future. So my comments so far.
Thank you very much, Judge Massetti. I would like to invite Judge Marcelo to address the group now, but here I'll put one question. As I understand, the embargos infringentes apply to one of the 2 charges. Right. There is one charge that stays, and the judgment on that is what it is. So, am I right, Judge Marcelo, if you could enlighten us a little bit more on that?
Yes. Well, I'd like firstly to thank for the invitation to be here talking to you today. And Oscar has made a very good briefing of the case, and Judge Peter Massetti also had very good emphasized that this kind of appeal, the embargos infringentes, does not allow the Supreme Court to change the core of the trial, of the outcome. So I'd just like to add that besides the conspiracy, the formação de quadrilha, there is also some questions about money laundering involving just a few of the defendants. But in essence, it won't change, as I said, the core of the outcome. So in my opinion, this trial will be, no matter what, a watershed in Brazilian criminal justice system, because it doesn't matter the outcome of the trial of these embargos infringentes. Some white-collar criminals are facing time in jail, some are staying more time behind bars, some will stay less time, but anyhow, they will face time in jail, and it doesn't matter the outcome of the embargos infringentes.
Just to let you know that now we see you and you all look very handsome.
Thank you very much.
You too, Paulo.
So I would like to say also that Judge Peter Macide has shown a deep knowledge of the case. It makes us very happy. It was a very good and very interesting analysis of the facts and of the whole political and judicial situation. So it makes us more comfortable to talk about that and see that you have already a good knowledge of the case. So as I said, having that in mind, that it's not possible to change the core of the outcome, I think the greatest meaning of this trial, as I said, is to show that in Brazil, with all the difficulties, some also white-collar criminals are infected, or at least we have the expectation that will happen from now on, are prosecuted, tried, and convicted in Brazil. On the other hand, watching this trial, that, as Professor Oscar said, it was broadcasted through the whole country. Brazilian people, and I mean lay people, regular people, could have an idea of the absurd complexity of our criminal justice. It is weird, it is too complex, and it is, at my point of view, completely outdated. The possibility, the jurisdiction to politicians directly, they are directly originally judged from the Supreme Court, is something that is, as my point of view, unjustifiable. No country in the world has, to my knowledge, a judicial system in which so many people are able to prosecute it and judge it originally by the Supreme Court. The system does not work in Brazil. Less than 5% of the cases does get to a final decision. This special jurisdiction also applies not always in the Supreme Court, but in higher courts, to governors, mayors, ministers, judges, prosecutors, and other authorities. So it simply doesn't work. It is clearly outdated and goes against the public responsibility in Brazil, and should be, as soon as possible, changed. And there goes another observation. It is just the tip of the iceberg. A regular criminal case has to be judged in Brazil by 4 different courts, not to mention the possible appeals that can be filed in each of these courts. If you consider on one hand that, taking all the possibilities of appeals into account, a criminal case is virtually endless in Brazil. And on the other hand, that as a rule, nobody can go to jail before the complete exhaustion of all the appeals, due to the understanding of the Supreme Court about the presumption of innocence, we have the formula of impunity. So I will advance some of the conclusions that I take from this trial, and we can go further later. But as I see, as I said, there are positive things to consider about this trial, but we can see also that we need urgently to simplify and downsize our judicial legal framework, especially our appeal system. And one of the immediate possibilities that doesn't require a change of the law is a better use of the institute that we call here repercussão geral. It is not directly related with these Mensalão cases, because it only applies to the cases that are judged from the lower courts. But that is, there is similar with the writ of certiorari that you have there, and that allows the Supreme Court to have some grade of, or a high grade of discretionary to decide if they will or they will not judge, for example, a criminal case, if they will receive or not an appeal. And in my opinion, the Supreme Court in Brazil has already the same kind of tool, but they don't use it as they should. And the other thing that seems to me that has become very clearly from this trial is that the Supreme Court should be urgently transformed in an authentic constitutional court, dealing only with constitutional matters. It is not possible that a Supreme Court from a country stops for 1 year just deciding from a criminal case instead of dealing with lots of other important constitutional matters. It shows, in my opinion, very clearly that this kind of cases should be judged by the lower courts, so the Supreme Court can be a real constitutional court and focus on what should be their real job. Well, those would be my first considerations. I thank you again for the opportunity, and I stay here to further questions.
Okay, thank you, Marcelo. I would like now to invite, after listening to two judges, one legal scholar, I would like to ask Matthew how all this all looks from the perspective of political science.
So thank you very much, Paulo, for the invitation to be here. It's really an honor to be here with these three distinguished lawyers and judges. I'm a political scientist, which means that in addition to not being as well paid, I'm probably best equipped to discuss the legal issues. So I'll try to touch on what's important here, but I want to take the picture perhaps a little bit broader and talk a little bit about accountability more broadly in Brazil. I think we've heard a lot about the actual Mensalão trial. I would argue that the Mensalão trial is really the exception that proves the rule. And the rule is the courts are the biggest accountability bottleneck in Brazil at this point. In a review of 10 major scandals that have taken place over the past 2 decades, journalists at one of Brazil's major newspapers found that of 841 defendants who were accused in these 10 scandals, only 55 had been convicted, so about 6%, and only 9 had received a final conviction, so just over 1% of these. The Mensalão will probably be decided next year. That means that it won't be decided until 9 years after the scandal broke. And somewhat ironically, this means that the trial actually moved along pretty quickly by Brazilian standards. And so as we think about accountability in Brazil, it's hard to avoid the conclusion that the courts really are, at the moment, the key bottleneck. And I don't have a lot of time to talk about what's changed in Brazil in terms of federal accountability, and that's what I study, the federal level. But if you think about what's happened over the past 30 years among federal accountability agencies like the Polícia Federal, the Comptroller General's Office, the CGU, when you think about what's happened with civil society, the creation of groups like Transparência Brasil, Instituto Ethos, Movimento Voto Consciente, Amarribo, all of these groups that have grown and really become very active players. When you think about the expansion of transparency, partly as a result of things that have nothing to do with accountability, like fiscal reform, the creation of the fiscal responsibility law, the creation of a transparency law. When you think about what's happened to the Ministério Público, which has been the prosecutor's office, which has become much stronger, much more autonomous in the last 30 years. You think about the creation of the Comptroller General's office, the CGU. You think about policies like the National Anti-Money Laundering Strategy, the ENCLA, which brings together a lot of government agencies to try to discuss how to improve accountability, and they've actually done a great deal to improve oversight. You think about international agreements, like agreements through the UN Convention Against Corruption, through the OAS. the voluntary submission of the Brazilian federal government to oversight from below as part of these treaties. There's been just an enormous growth of accountability efforts within the federal bureaucracy. And this continued, and I think to avoid any sort of partisanship here, I would say that the Lula government inherited a lot of this, but it also deepened a great deal of this reform, and it's continuing. Lula appointed very dynamic leaders to head the Justice Ministry, to head the federal police, to head the CGU. There's been new leadership in the Tribunal de Contas, which is the accounting body. The number of personnel in accountability agencies has more than doubled at the federal level since 1989. Within the federal police since 2003, you've seen a 50% expansion in the federal police, and I think a fairly active effort to root out the most corrupt police. The ANCLA, this anti-money laundering strategy, produces lots of important policy changes that are marginal. They take place at the margin, they're very incremental, but they nonetheless add up over 30 years to a really important change. And the number of civil servants, just to give you one example of how this has gotten better, the number of civil servants who have been removed from their posts or expelled for malfeasance has more than doubled in the past 7 years, as has the number of audits undertaken within the federal government. So I'm only talking about the federal government. The picture at the state level is not necessarily as good. And there are, of course, problems like friction between the agencies, the abuse of power by places like the COAFI, which is the Financial Activities Oversight Body, or the federal police. But what we see is that despite all of these improvements, we run up against the courts. And I don't want to underplay the importance of the Mensalão. The Mensalão really was a very big deal. The fact that they not only convicted 25, but they actually also absolved the other defendants. This is very important. This was a major trial, and there were, of course, debates over the prevailing legal rules, but the STF, by and large, has done its job in a way that I think most neutral observers will agree has preserved the rule of law. But, again, this is a case which proves the rule. It's the exception that proves the rule. We see here the use of legal rules that date back to the 1940s, a plethora of laws that are on the books that were developed under different political regimes. That leads to some uncertainty, for example, about the embargos infringentes. In many corruption cases, not necessarily in this one, we have the possibility of these recurring interlocutory appeals, procedural delays to run out the statute of limitations. One thing that I think we have to remember in Brazil that makes special standing so important, this possibility of the foro privilegiado so important, is that there are 90 million court cases underway in Brazil at any given moment, and that's not, larger than the U.S., but what's very different from the U.S. is that the congestion at the top of the judicial pyramid is much, much higher. And so overall, what we see in Brazil, and I think this is understandable in light of Brazil's authoritarian history and the return to democracy, is a decision to privilege what they call the amplo direito de defesa, the broad right to defense, over perhaps other criteria. So maximizing appeals, maximizing the possibility of appeal over efficiency or perhaps equality. And one of the most important considerations that I think comes out of this is the delays of the courts make it very difficult to remove corrupt players from the political game in an efficient way. And so they continue to behave, or it's possible to have corrupt networks that continue to operate over the long haul. So the STF is extraordinarily poorly equipped to hear criminal cases. As others have mentioned, it's taken us 7 years to begin to hear this case, 63,000 pages of evidence, 600 witnesses, somewhere between 50 and 60 sessions by the full STF, Judge Marcel, I think, mentioned the fact that this means that they can't work on other things. They cannot work on constitutional appeals. Celso de Mello's vote last week on the embargos infringentes took him 2 hours to read. This is, I think, a sign of some of the issues. And
Yeah,
so...
I think it was more like 3.
Okay, well, so, you know, I'm glad to hear some of those who preceded me talking about the need for reform. Unfortunately, it's been very difficult for there to be any reform. And as a foreigner, when I look at Brazil, this is what strikes me most, is it's very clear that the courts are one of the chief bottlenecks, if not the chief bottleneck, to accountability for corruption. And yet calls for reform since 2004 have been relatively mild. Now, I think, again, trying to be apartisan here, there are reasons that reform is not desired by anybody, including the fact that there is a Mensalão, so-called Mensalão Mineiro, that's still to be heard. There are plenty of scandals to go around for all parties. Recently, we have the Sao Paulo allegations, accusations against Delta Construção, and so forth and so on. And this takes me to my second conclusion, which is what I expect is likely to happen is an increasing politicization of the courts. We've already seen this in constitutional matters. I think that in accountability issues, in anti-corruption issues, it's very possible that we'll see much greater politicization of court appointments, and we've certainly seen much more careful vetting of justices from here on out, well, in the last 5 years. And some of this relates to something that Judge Massetti mentioned, which is the fact that all of these decisions were, or all of the deliberations were made on live TV, and that makes the STF somewhat of a lightning rod. So, just to conclude, I'm very optimistic about the construction of accountability in Brazil, especially as we look back over the last 3 decades. We should be very optimistic about how democracy has changed beliefs about social status, about elite privileges, about clientelism, and about corruption. But I think any serious analysis needs to come back to the role that we expect the courts to play and to their role as the largest bottleneck in fighting corruption.
Thank you, Matthew. With that, I would like to, unless some of the speakers have a quick observation to make, I would like to start the Q&A. And we agreed that we will have one question from here, from the Wilson Center, and followed by a question from Getúlio Vargas. But yes, Judge Massetti, please.
A couple of quick points that I'd like to make. Number one, bear in mind that only 12 of the 25 people have filed these embargos infringentes. The other 13 or so, or maybe less, they're ready to go to jail. That's been done already, so there's nothing pending anymore. Those appeals are over. Another important point to bear in mind. The second thing that I want to say is that with regard to the issue of statute of limitations, and for this I owe a debt to Dr. Luciana Mendes, who is working with me, who's a prosecutor from São Paulo. It's a little bit different with regard to limitations in Brazil, because if you are not charged within a certain period of time, or your sentence is not imposed within a certain period of time, you're out free. Limitations run, prescrição. It doesn't happen in the United States. Once you're charged, it may take 10 years to get to a result, but then you go to jail and you do your time. And while the appeal is pending, you go to jail. You're not free. Once you're convicted in the trial court, the presumption of innocence goes away. You might be able to turn it around, but you go to jail. Take the example of Governor Marvin Mandel of Maryland. He went to jail for 3 years, and then his conviction was reversed. He went back and became governor again. So that's the way it works here. We sort of, there's no time for waiting around. If you're guilty, you're guilty. So that's the final thing. Some other time, Matt, I want to talk to you about judicial reform in Brazil. I have a different take on it than you, because I've been doing this for a while, and I've seen a lot of movement in the last 45 years or so, but we can talk about that another time. But the other interesting issue is, yes, There's always open debate by the ministers on the Supreme Federal Tribunal, right in public presence. Our Supreme Court doesn't do that, obviously. Everything is secret, and you don't know the decision until it's announced. All you know is the press reports on what the arguments are. Enough said.
Well, thank you very much. Oscar or Judge Marcello, unless you have some observations, could we go straight to questions?
Please. Just one observation regarding one point that Justice Massetti said, and perhaps I a little bit disagree, is regarding the presence of embargos infringentes in every level of the court system. He is right in this point, but there is a specificity here, which is courts like state Supreme Courts, which are large courts with more than 100 members. They are divided in several cameras. So normally a case is trial by one of these cameras. And then you have the embargos infringentes when you have a divergence inside of the camera to bring the case to what we call the plenary of the court. So it's not a common thing to have an embargos infringentes from a decision of 11 judges to the same 11 judges. So that's just a little specific thing that perhaps we should bear in mind. So that's why it caused some debate if it was a case to have this appeal at the Supreme Court. I'm not saying the Supreme Court decided wrongly, not at all. I'm just saying that it is of the nature of this appeal to solve problems when you have a section of a larger court deciding the case. And just another paradox, perhaps, I'm now reacting to what my friend Matthew said, is that we all criticize the privilege forum for many years in Brazil, and I fully agree with Marcelo that this is a thing that doesn't fit with a democratic society. But it was the privilege forum, the first one to grant a very strong case against corruption in Brazil. So that is part of the paradox. It's really an exception. It is a bad exception, but it is an exception that perhaps will destabilize the system that is not functioning at the court level, as Matthew correctly posed.
Okay, thank you, Oscar. I will ask people asking questions to please identify themselves, and we will have, we'll start on this end. Please go ahead.
Thank you. My name is Christina Serna. I'm an adjunct law professor at Georgetown. I come to this meeting with zero knowledge about this case and the Brazilian legal system. And I want to thank the four presenters for really excellent and fascinating presentations. I've read a little about the case in the press, and what I'd like to know is, how did this case ever arise? Since President Rousseff is a handpicked successor by President Lula, and the idea of having a successor government bring a criminal case for corruption against, clearly it involved President Lula and his administration. What was the role of President Lula in this case? Who are the 12? These are 12 members of Congress. Is that why they got the privileged forum? And the other 25 are carried along because they're involved in a so-called conspiracy? And also, what kind of sentences did those who were convicted get? Thank you.
Who would like to take that one? Oscar, do you do that?
Marcelo could start.
Well,
Okay.
firstly, I think that this prosecution can be credited to something that Matthew said, that is the autonomy of the Ministério Público. Actually, it had really worked in this case, and they felt no pressure. Actually, probably there was some pressure to not take it longer, but it worked well. The Polícia Federal has also worked, and the case has been brought on. And
Marcelo, could you explain what the Ministério Público is and how it relates, for instance, to in the United States? What's the equivalence?
Equivalent to the U.S. Attorney in the United States.
Okay, go ahead, Marcelo.
okay.
Oh, just one thing. It's interesting, the General Attorney Office, but the difference is that it is a career. Today we have around 15,000 members of the Ministério Público that are not appointed by any politician. They pass in a very hard exam. Perhaps it's the hardest public job to get in Brazil besides being a judge. So they are very insular to political pressures. Just this is a difference between the U.S. and Brazil.
Yeah, they are called the fourth power besides judiciary, executive, and the legislative power. So that would be the first question, and the second was about the other people, the other defendants that are being accused together with the congressman. That is correct, Christina. These other people, they are being charged and they are being prosecuted in the Supreme Court because they were in the same conspiracy as the congressman. So the Supreme Court in Brazil has this understanding that they should be all judged together. And I think the role of Lula, you asked in the last part of your question. Well, I think that although he had made some comments about the case, he had, in my point of view, he had behaved properly. He didn't had intermised. He didn't had made any pressure over the investigation. So the institutions had really worked in this case, and it had went forward without interruptions.
I will ask, I think, Judge Massetti to summarize, at least to highlight. There is a former chief of staff to President Lula, José Dirceu de Oliveira, who was being prepared to run for the presidency after the second term. He is the principal figure in this. There is a former president of the Workers' Party, was a federal congressman. There is the former Speaker of the House, also a member of the Workers' Party. Those are the. If you would, Peter, give us a little bit.
Let me. Actually, again, thanks to Luciana Mendes who prepared this chart for me. I'll just give you a quick example of who was who and what they got. José Dirceu was the ex-minister chief of staff for the Lula government, and he was found guilty of conspiracy and active bribery, got 10 years. Delubio Suarez was the ex-treasurer of the Workers' Party. He was also found guilty of conspiracy and active solicitation of bribe, and he got 9 years. José Genuino was the national president of the Workers' Party, also charged with and found guilty of formation of the gang, which is conspiracy, active bribery, and he got 7 years. Marcos Valerio, public relations person connected with the scheme, was found guilty of a number of things, including conspiracy, active bribery, theft, and money laundering, and so on. And I can't even total the numbers because they get really high in double figures. But that's an idea of who was involved. Main point, they are members of the Workers' Party. The president is a member of the Workers' Party. Lula was of the Workers' Party. An interesting concept.
Paulo, we are not hearing the question.
We need the microphone here. Why would be the government bribing
Members of its own party. Wouldn't members of the party tend to vote in favor of what the president is of
It
their
wasn't
own party?
bribing its own party. It was bribing another party
Ah.
to join in the coalition.
These are the bribers, not the bribees.
Just for context, let me explain. In Brazil, the government is organized around what we describe as presidentialism by coalition. Okay, the president is supported by about 10 political parties. We have, 36, 26, I don't know. It's a big country, we need a lot of political parties. Okay, so what happens is that the president, in order to govern, has to keep this coalition together, and it takes normally, depending on the issue at hand, the president has to have the allegiance of the members of those parties, and normally has to negotiate that in the morning and renegotiate that in the afternoon, depending on the issue, and the price may go up. Now, what seems to have been the case here is that instead of doing what other presidents did, which is to negotiate, to use patronage, to use whatever, in that sense it's not very different from here or any other country. It looks like there was, and this was the charge, that there was a conspiracy inside of the government to make this more efficient, let's say, by paying monthly stipends to members of allied parties to guarantee their allegiance, their support. This, therefore, the expression Mensalão.
Paulo, just for the, for the sake of the debate, let me give a little bit the view of the defendants, which was, well, this was not bribery. We were part of a coalition, and this money came to us as part of a scheme to help us campaigning. So they are not paying the votes. The government was finding money. You can say that there was an illegality on this, but the money was not an exchange for votes, but was money sent to the parties so they could do their campaign next year, just to see how it works, because they were part of the coalition. And one member of this coalition, one very important politician, had a disagreement with the chief of staff, and he was the whistleblower. He was the one who brought all the scheme to the public. And those involved in the scheme defend themselves, saying this was an unorthodox way of raising funds for the campaign. Just and the court didn't accept this view. But this was the perspective of the defendants, which the Supreme Court didn't buy.
And the congressman that started all that responds by the name Jefferson. I'm sorry. A question from Fundação Getúlio Vargas, please.
I have a question. Do they hear me?
Yes.
Just speak louder. Yes. I'm Pedro. I'm a student in Fundação Getúlio Vargas, a law student. I'll probably leave a bit aside the debate regarding Mensalão, and my question revolves around comparisons between the United States and Brazil. It's a very disputable whether the fact that we've got a broadcasted Supreme Court is actually something good or bad. Normally in Brazil we would see people gathering in front of television to see football matches, but recently we've seen people gathering in front of television to see a judicial trial. So one could claim that, well, this could have a sort of a educational purpose. But I'd really like to know what you, Professor and Judge, understand. How do you see this? A Supreme Court, which is broadcasted, the debate between the judges is broadcasted. How do you see this, the impacts, and compared to the Supreme Court of the United States, which is completely the opposite, meaning even the debate is not publicly revealed and only the decision. So how do you see these questions of our Supreme Court being broadcasted?
Yeah, I'll ask Matthew. Remember, there are trials that are broadcasted in the United States. Some of you may remember the trial of a famous football player called O.J. Simpson.
Yeah.
But you are right, in the Supreme Court, there has been a debate about that, right, Matthew?
Yeah. So I guess I'll take your question more broadly. I think that the issue of whether it's televised or not, maybe we can set aside. But I think that the larger issue is the politicization of the STF. Because the Supreme Federal Tribunal in Brazil, because of this problem that I think Judge Marcelo pointed to, the lack of use of the repercussão geral, the lack of a writ of certiorari, it means that the apex of the judicial system has to hear everything. And so, for example, the STF receives somewhere between 80,000 and 100,000 cases a year. And when I wrote this one time for an American political science review, I got a rejection outright saying, this is impossible, this person doesn't know their numbers. And you know, this means that the courts have to address a number of issues that are politically difficult. Some of these issues are constitutional, but in the Mensalão case, and I think increasingly from here on out, they will be criminal as well. And so whether it's televised, I think you're right, whether it's televised or not may not be the most important issue, and in fact, televising it may be educational. But the fact of the matter is that the STF has, as Oscar has written, you know, been pushed into a very important political role.
No, but, Judge Massetti, enlighten us about, because there was a debate some 10, 15 years ago about whether to allow television. There was first about Congress, then it was finally allowed, 20 years ago maybe, and then on the Supreme Court. How was the debate, and why they finally decided not to?
Well, here you have to distinguish between federal justice and state justice. In the federal courts, cameras are not allowed. There's an experimental program in some of the federal courts of appeal that allow arguments, but not in the district courts, and that is a flat policy, and it's not going to change. Some of the state courts, they have their own option. They can televise their state proceedings, and some do, California being most prominent among them. I might say, obviously, the O.J. Simpson case is an example of how bad televised proceedings can be. You had prosecutors and defenders who were grandstanding, and you had a judge who really couldn't handle the press and so on and so forth. It really made the whole trial look rather pathetic. And the general rule, I think, across the country is the courts just don't want it. They don't think that televising the proceedings are conducive to a fair trial. Having said that, though, we're talking in this instance about televising proceedings of the Supreme Federal Tribunal. And I see that really as a very interesting educational opportunity. It is the procedure of the court in Brazil not to have closed-door sessions about how the case is going to be resolved. Someone will be designated as the relator, the reporter on the case. They will write a decision, and then that will be openly debated where the public will sit in. That's rather intriguing. And it does, in fact, invite criticism, but it also educates.
Now, let me, since we're talking about the education impact of that, let's just run a little Q&A demonstration here of the students there. I assume most of you guys are law students and very young people. I think we have also some students here. Please, the 30 and under. If you are more than 30 years old, you're not supposed to respond to this question. A show of hands. Do you think that televising judicial procedures is a good idea or a bad idea? Show of hands, please.
Which
one? Good. It's a good idea. Who thinks it's a good idea? Raise your hand. How about here? How about here? Oh, well, I think here it may be a tie, but there it looks like most people do not like the idea. Yes. So let's have a question from here.
Paulo,
Yeah.
I was surprised by the result in any case. So since I'm a little bit older than 30, no, it's interesting what Matthew said. First, Brazilian courts decide in public. This is a constitutional clause, so every act of the court is supposed to be public. So in any event, a small court in a little city and the Supreme Court, they all deliberate in public. So this is part of our Republican tradition, and I see no sign of change on this, and which is a good thing in terms of public scrutiny, of transparency. We are, I think, very happy with that. What happened with the Supreme Court is that in the case of the impeachment of former President Collor, people were so eager to know how the court would be deliberating this case, and that the president of the court at that time allowed to be televised. And since then, in major cases, the Supreme Court cases were televised. So, but there is this constitutional principle that every act of the government should be public, and the judiciary also. And that's how it became televised. My friend, professor here at our law school, Theo Dias, a very important criminal lawyer, said that perhaps in criminal cases you should be acting differently because you could have a public perception that would influence the justices or the jury. But I would say that in other cases, television made a very good impact on the Supreme Court in the last 20 years that were established. Disagreeing with my students.
Well, let me just add one thing that I find personally very interesting here. Obviously, all deliberations of the Supreme Court, they're obviously open, they're public, but the space is not, there are limits of space, so people are, they first come, first served, I think. What is the process?
In our Supreme Court, the decision is already made. They may hear argument, and they may answer questions on argument, but then they deliver opinion.
Yeah, no, what I find personally very interesting as a journalist is that the decisions of the Supreme, there is in journalism in the United States a specialized group of people that are journalists that interpret Supreme Court decisions. And there are some absolutely amazing texts and amazing, there is on PBS, on the TV Educativa equivalent here, there are a couple of people that are absolutely outstanding in translating to everybody what the decisions were, what are their implications, what they mean. And this is probably something that we will have to develop in this, is to translate the rule of law to people. And it's a major challenge for journalists also. We need a question from here. Steve.
Tom O'Keefe from the
Tom.
that's right. Tom O'Keefe from the Foreign Service Institute. I have a question directed to Marcelo Cavalli. The statistic that you quoted, that less than 5% of criminal cases go up through the 4 procedural steps before there's a final conviction, is that across the board all criminal cases in Brazil, or is that just cases that end up in these foro privilegiados? And the other question I have too is, those who are convicted in a foro privilegiado, do they end up going to a regular prison, or is there a special prison system for them as well too? Thanks.
Okay, first question, this statistics is referred only to those who have foro privilegiado, not only to the Supreme Court, but also in the other courts. As I mentioned, for example, I'm sorry, I'm in the wrong microphone. So these statistics are referred to foro privilegiado, not to regular cases, but not only for the Supreme Court cases, because as I mentioned before, governors and other authorities have also foro privilegiado in other higher courts. So it only applies to foro privilegiado. And referring to the second question, it should be in the end of the criminal cases, when there's not, when there are exhausted all possible appeals, then there is not different there should be not a different kind of jail to these people. But we've heard about some movements here to keep these people separated from the other. But there is a rule of law that allows some kind of people during the criminal judgment, when they are arrested, not to be together with regular criminals. But once the criminal case is ended, then there's no more this distinction. Sorry.
Okay, question from São Paulo. There is one in the back there. If you could, either you shout or you come up.
So my name is Victor. I'm also a student here at GV. And my question also concerns the comparative system. As we discussed, the politicians in Brazil, and Brazilian system are tried by Supreme Court, which is not well equipped to do so. We'd like to understand how a politician trial occurs in the U.S. system. Do they ever reach the Supreme Court?
Okay. It's about the nomination process, the Supreme Court, and he is asking whether politicians.
No, sorry, Paulo.
Is that what it is?
No, the question
Oscar,
was-
repeat the question.
Yeah, I think the question was how a politician would be tried in the U.S. system, if a senator or a member of parliament, and if the case would arrive in the Supreme Court at a certain point.
Politician.
Politician is treated like any other criminal defendant. If the politician is charged with a federal crime, they would be first tried in the United States District Court for the district that they are in. I am a United States District Court judge, and I would hear the case, whether it's the president or vice president or a senator. That person could then appeal the conviction, and they would have an appeal of right to the next level court, which is like the federal regional tribunals of Brazil, to the Court of Appeals. Whether the United States Supreme Court would hear the case would be up to the Supreme Court, because they have what is called discretionary review, what you in Brazil call repercussão geral, and they may or may not hear the decision. And that's the end of it. There's nothing more to be talked about. There's just absolutely no different treatment for a politician, regardless of the level that that person served with regard to the criminal justice system. Most of the cases against politicians do get tried in federal court, and the fear is that the state courts, particularly if they are state politicians, may be too biased in favor. The federal courts are considered more impartial. But that's the short answer.
Thank you very much. Now we have a question from here. Yes, that's right. And Tom, apologies, because the problem after knowing people for 25 years, the problem is that with age we start forgetting everything. I used to forget. Tom, dear, Tom's name, my dear friend.
Hi, my name is Tim Rideout. I'm a fellow at the German Marshall Fund, and my question is also, it's more for the Brazilians, but it's comparative. As I understand, the Ministério Público is enshrined in the Constitution in a way that the U.S. Attorney's Office is not. And that's, I believe, that's why it's considered sort of the fourth pillar in the Brazilian system. And there was also, with the PEC 37, the proposal to amend the Constitution that was essentially tabled in June amid the protests. Was that, and I believe that the amendment would have weakened the Ministério Público. And I was wondering if you could talk more about that, how this fits into the trial and how the Brazilian system operates.
Okay. Yes, you are right. The Ministério Público is a very peculiar institution. You have state Ministério Público and you have the federal Ministério Público. So you have, each state has its own Ministério Público. There is an interesting and important difference from the Brazilian Public Attorney General office and most of the Attorney General office around the globe, which is it's not only active on criminal cases. Okay, so the Ministério Público is a mixture of an ombudsman and a ouvidor, because it takes cases in several areas, like environmental law, like consumer law, indigenous people. So it protects the social interests of people. So it is extremely powerful because the Brazilian Constitution is very generous on the rights it grants, and the Ministério Público could bring cases on behalf of the society. So all the class actions in all these areas that I said are Ministério Público that brings to the court. So it is a powerful institution. They are constitutionally insulated from politicians. Their members are co-opted through this meritocratic process, through a public contest. You could have 50 places for federal prosecutors and 25,000 lawyers and young lawyers around the country doing this test. So it's very insulated. In the top, they promote an election and provide a list of 3 of their own members to be set by the president as the general attorney. So the general attorney is selected by the president in a list of 3 members of the Ministério Público that were elected. And then the Senate approved this. So if you take this case of Mensalão, the person who brought the case against important members of parliament, they were in fact selected by the president, but through this filter of the institutional filter. So this is one point just to understand how the Ministério Público functions. Well, regarding the PEC 37, which was a draft amendment to the Constitution that was posed, then is another dispute. Is a dispute between the federal police and the Ministério Público, because there is a debate that investigation would be a monopoly of the police. And members of the police are saying that the Ministério Público are overstepping the jurisdiction of the police because they are doing their own investigation through new equipment called inquérito civil, a civilian inquiry or something like this. So the PEC 37, it was a debate about this. Would the investigation process be kept as a monopoly of the police, or the Ministério Público would be allowed to do it? In the end, what you have is that since the PEC was not approved, grace to the pressures of the streets, so the decision is that the Ministério Público is kind of competing with the federal police by also producing investigation. I don't know if you want to correct me.
Now, one clarification that maybe Judge Massetti will. Here in the United States, my impression, at least at the federal level, is that the police works under the guidance of the prosecutor. Is that what it is?
Well, when you're talking about federal, there's really no federal police. You're talking about the FBI and all the different law enforcement agencies at the federal level. Sure, at the state level where there are police, they are always under the direction of the prosecutor. There may be things that happen on the street and the police become aware of a crime and bring it to the prosecutor. But investigations, the whole decision to prosecute is entirely in the hands of the prosecutor. In fact, prosecutors can choose not to prosecute what is clearly a crime. That's how broad their discretion.
Okay, question from...
Let me just respond one thing. It's true there are differences between a member of the Ministério Público in Brazil and a member of the U.S. Attorney in the United States, but it is also true that the Department of Justice, which is the main center where our U.S. attorneys work, is responsible for prosecuting environmental crimes and all the other kinds of crimes that you find in prosecuted by the Ministério Público in Brazil, and maybe the Environmental Protection Agency that brings the case, or the Food and Drug Administration. I mean, there are all these public interest prosecutions are carried on in the United States. Separate word, it's true that there has been some political influence over the years in the Department of Justice. particularly during the Reagan and George W's watch. But for the most part, there's a tradition of independence in the U.S. Department of Justice, with career prosecutors who are committed to, how should I say, doing the right thing. And so they aren't really totally under the control of the administration.
Well, question from Fundação Getúlio Vargas, please.
My name is Denis Guimarães, and I am a former graduate student from Fundação Getúlio Vargas. I have a question about the possible role of the Organization of American States in this trial. Paulo Sotero mentioned the role of José Dirceu in the case, the former chief of the civil cabinet of the Lula administration. And José Dirceu has been stating that after the case is finished in the Brazilian Supreme Court, he will try to appeal for a kind of a human rights review that could take place in the Organization of American States. I would like to know if one of the panelists would be able to make a comment on the legal feasibility of this idea, of this strategy. Thanks.
Actually, we have a person here in this room that knows
I'm sorry?
a lot about this, and the idea here is that after this process, the trial ends, that case would be brought to the Inter-American Human Rights Commission. And Chris, could you enlighten us?
Sure. I should add, I recently retired from 33 years at the OAS, most of which was with the Inter-American Commission on Human Rights. For the case to come before the commission, the victims would have to allege a violation of specific rights set forth in the American Convention on Human Rights. But should they be able to do that, alleging, say, for example, violation of due process or access to justice or whatever complaint they have about the proceedings, they are certainly free to present their case before the Inter-American Commission. And since Brazil is a state party to the American Convention and has accepted the compulsory jurisdiction of the Inter-American Court of Human Rights, which sits in San Jose, Costa Rica, the case could eventually come before this court, and the court could issue a legally binding judgment in the case.
Thank you.
Thank you for the question.
Well, the context of this is also interesting, because there was not long ago, and I wrote about this a bit, there was a decision by the Inter-American Human Rights Commission regarding involving violation of indigenous rights in the area where the Belo Monte hydro plant is being built. And the decision by the commission, it was called a what? A precautionary measure, and as a precautionary measure, the commission basically told Brazil to stop construction of Belo Monte. And I don't know if you there in São Paulo remember what happened, but there was a very, very visceral reaction from the part of the president, Dilma Rousseff, and the relationship became very strained to the point that Brazil, for a while, did what the Brazilian government had a few months before criticized the United States from doing, when the United States stopped payment to UNESCO. For a while, we stopped payment to the OAS because we didn't like what the Inter-American Human Rights Commission was doing. In this instance, I think, and I said that in another place, I think that obviously the commission is a political commission. It's not a commission of nations, it's not like the UN Human Rights Committee, which is of nations. It's a commission of citizens, of experts. There is one Brazilian there, actually Paulo Vanucci, who is a former human rights minister in Brazil. who succeeded Paulo Sérgio Pinheiro, a former human rights minister in Brazil. And it is a politically touchy thing because of the perception in Brazil, the political perception about this case, the political content of this case. I personally believe that the commissioners here at the OAS should think long and hard about this case, if the case is brought to them, because there could be adverse consequences to the image of the Commission in Brazil. On that, I would like to ask my little question here to my friends in São Paulo. Depending on how this case goes, if, for instance, instead of being a review of sentences, this becomes a retrial, do you foresee the possibility of people to manifest their insatisfaction in the streets about this? Is there such a possibility, such a component, or it's not? What do you in São Paulo say about that possibility?
I'd just like to add about the possibility of an appeal to the OAS that if this case didn't observe the due process of law, we should overrule all the criminal cases in Brazil, because I have never seen so much possibilities of defense as in this case. And about the second, I don't think so, because as was mentioned before, there is the possibility of changing is too narrow. There's not too many things that can be done, and this kind of appeal does not appeal the Supreme Court to change the core of the decision. So the majority, or at least a large number of the defendants, are really going to jail, and this is not possible to change. For instance, I believe that the question that most interests the media in Brazil is if José Dirceu is going to be in jail in the closed regime, in the real prison, or he will be in an open place where he can work and etc. That's probably the most interesting question, the most important question for the media in this case. If he can move to not be in a prison, I don't think it will be enough to mobilize people to go and protest. So the major changes that can happen, in my opinion, won't be enough to make it change.
Yeah.
From here?
Yeah, but just to add something, yeah, it is important to mention that all these 12, they were convicted by several charges, and not all the charges are on appeal now. Just those where the convictions were not for a extreme majority. So yes, even though if they were acquitted on conspiracy, they are already convicted by corruption. So there's no way of removing this charge of corruption. So there's no possibility of reviewing the whole case. Regarding the Inter-American system, is just one point. The only possible claim is about the right to a review, because this is an Inter-American convention, and since they are trial in a privileged forum, you don't have the possibility of. The Supreme Court has solved this before in many other cases and said that this is compatible with the due process clause in Brazil. So then you would have a conflict between an interpretation of this clause by the Brazilian Constitution and an interpretation of this clause by the Inter-American Court. And the Supreme Court already said also that in Brazil, its decision is supreme than the decision of the court. So that is what the precedent stands at this moment.
Yeah, just one, I'd like to add, Chris, one information I'd like to add, I think they didn't mention. The majority of the judges that decided the Mensalão case, and who decided, were nominated to the court by Presidents Lula and Dilma Rousseff. So it's virtually impossible to make a case that this is a as some politicians have tried in Brazil, that this is a political trial. The people sitting there were nominated, starting with the President of the Supreme Court, Joaquim Barbosa, was nominated by President Lula. Only, I think, of the sitting members now, there are only now 2 or 3 that are not. Marco Aurelio Melo, Celso Melo, and Gilmar Mendes. Yes, there are only 3 that were nominated by presidents before Lula. Question here.
Yeah, I would like to know if you see...
Say, identify yourself, please. Just.
Oh, sorry. My name, I'm Brazilian. I'm here at UC to a master's degree in Georgetown University in democracy and government. And I would like to know if, because it's a political struggle, and Lula, yeah, he did a movement last year. He tried to influence a justice of the Supreme Court. He went to a lawyer to an office, and there was a sort of interference, but it didn't result. And I think it's quite different when you nominate justice before the judgment, and now Dilma has nominated 2 of them, and I think that's will make the difference how they are going to judge the next judgment. Yeah, os embargos inteligentes, the appeal, and that's what I would like to know, what you here in America think about it, because the justice, they are going to be nominated during the trial. And,
should they excuse themselves? That's what.
Yeah. Okay. Because Justophiles didn't, and they will not. They will not, because well, it is a political
let
struggle.
Me just clarify what she is referring to. There was reported in the media, not denied, President Lula, when the trial was about to start, went to former congressman, former minister of his government and of the Fernando Henrique Cardoso, Minister of Justice of the Fernando Henrique Cardoso government, former member of the Supreme Court, former president of the Supreme Court, Nelson Jobim, who has been in this building more than once, participating with us here in seminars. And Nelson Jobim and Lula met with Minister Gilmar Mendes, and that was with what appeared to be an effort to try to delay the trial. And that's what I think she was referring to now. Anyone here could answer the question?
I mean, would that happen in the United States? Be outrageous if it did. I can't imagine that the executive would in any way try and influence the deliberations of the court. It may have happened historically. There may be some few incidences, but I really, it's just something that totally would be unheard of here.
Things here, obviously all decisions have a political element to it, but the only pretty obvious recent time political decision that was political was that involving that Florida business in 2000 that led to the, as some people would say here, instead of the election, of the selection of George W. Bush to be president of the United States by 1 vote, which was a decision, a split decision for...
Well, yeah, but it's one thing for people philosophically to come to that decision. It's another to be an attempt to have it influence their decision to come that way. There's no indication that someone tried to contact the justices in Bush versus Gore. They philosophically came to the decision they came to. I happen to think it was political in the sense that it represented a point of view, but no undue influence was ever suggested in that.
Okay, question from São Paulo, please.
We have, my name is Alexandre. I'm a master law candidate here at Fundação Getúlio Vargas. And we have a question here with my friend at GV. In Brazil, you have at the Supreme Court has a judge that has much more experience than others, because such judge was nominated kind of time that now is called here the decano. That is a judge that decided a lot of special cases, sensitive cases in Brazil, when there is a kind of tight decision in Brazil. Celso de Mello is now the older judge, not in terms of age, but in terms of experience at the
Oldest serving,
Supreme
I think
Court.
we would say the oldest the oldest in the court.
Yes,
serving
yes.
there. And the name in English would be, he would be the dean of the court, I think, right?
All right,
In that
all right.
criteria. Yeah.
Decano in Brazil, thank you. He decided to accept the embargos infringentes here. Our question is there a kind of justice in the Supreme Court with this kind of experience or with this kind of mission in the Supreme Court in the United States?
May I, before I pass the floor to you, just to, interact
To
with
improve
my colleague here.
The work.
Celso de Mello has not any special way of voting. He's just the last member of the court to vote because he is the senior member of the court, and they vote in an order which is from the youngest to the oldest. So. And the logic of this is to give freedom to the youngest member of the court, the junior member, to provide its own vote without the influence of the oldest. So just to say that he doesn't vote twice, or his vote is not in any way more important than others. In many cases where the majority vote, like 7 votes in favor of one thing, he will vote in the end, and then he will lose. Just to tell that it was important because it was a tight vote at this moment. I'm sorry.
Yeah, now, Jess, I want Judge Massetti to respond to that. I am inclined, and I think the answer is no. There is no special anything. Although there are some judges that would love to have that. I can think of one. That really doesn't miss an opportunity. It's very funny,
So there's no issue of seniority as far as who has more influence than another in terms of how they decide cases. The only parallel, I think, is during these closed arguments that the court has, the youngest justice speaks first, for the same reason that the young ministro would write an opinion first. Bear in mind, though, we don't have cases where each judge has to write an independent decision. Ordinarily, we try and get a unanimous decision, or maybe you get a concurring decision, which is an agreement for different reasons, or a dissenting opinion, which is I disagree, but you don't get 9 different opinions, or 11 different opinions.
Judge, correct me if I'm wrong. I think now what we have is doing the arguments. I think they now tape the arguments, and you can hear later, and NPR does that very well, where since sometimes they disagree vehemently.
They do.
And so there is a very interesting and pedagogical, I think, aspect to all of it.
There's a funny story that some of the justices dominate the conversation. Justice Scalia is famous for talking a lot, but somebody told me once that, and I think actually this is a story from Chief Justice Rehnquist, who repeated this story at a small dinner that I was at a few years ago. The American Medical Association had a case before the Supreme Court, and they wanted to see what the justices were whispering back and forth to each other, so they hired a lip reader to try and see what the justices were saying. And one of the justices, like Justice Scalia, Justice Frankfurter, spoke a lot, and they saw Justice Douglas talking to Justice Black, And the lip reader came back and said, what he said was, I wish Felix would just shut up.
Now, let me ask you, Judge Marcelo here, and since you're a very young judge, and I hope that you are going to be one day a member of the Brazilian Supreme Court, and you guys sitting behind, and Oscar, talk about this. Do you really need 3 hours to state your case and announce a decision? And Marcelo, when you become a member of the Supreme Court, can you promise me to be shorter, to be a little bit more concise? Do you guys think that it's part of the reform coming, that these people should be a little bit more to the point?
Yeah, I promise you, Paulo, please, if you could indicate me in the future, I'll be very glad.
I will.
I was talking to Oscar before this debate, and we were talking about that. And he and Minister Justice Barroso, before he had become a justice, they had already proposed to the court that they should limit the time of voting for each justice. And well, in my opinion, that is also unjustifiable. We cannot understand how it happens. And there's something here that should be emphasized, is that in the U.S. court, in the U.S. Supreme Court, we can see there's a lot of debates. So the justices hear the arguments and they talk about it and they make logic argumentation and contrapose the arguments and etc. And here in Brazil it doesn't happen. For example, you've mentioned Minister Celso de Mello vote. His declaration of vote was too long, like almost 3 hours, but there's no real debate. In another question, Justice Rosa Weber, for example, having been questioned by another justice, instead of discussing the argument, had just said, okay, it's your opinion, I have mine. So if they have already their opinion, why should they get together and do it orally if they had already made their decision? So that's something that you cannot explain. They get together, they start with the case, and each of them has 2 hours to read the vote, and they don't change their mind during the debates. So it's something that is more a formality than something that really works. And I think that that can be that is due to in Brazil we have a very, very formal legal formation, and perhaps that will change. But in the future, if I get to the Supreme Court, I promise I'll change that.
Let me play the devil lawyer for a second. One thing, in 95% of the Supreme Court cases, what the rapporteur says is followed by the others. So it's good when you say, Matthew said, I always have the same problem. When they say, well, the court decided 60,000 cases last year, say, you are lying. No. Yes, we were telling the truth, but 95% of these cases were very swiftly decided by a unanimous court with the rapporteur winning, because they are simple cases that are repetitive cases. So it is another problem of the process, of the structure of the Supreme Court, the repetition of cases, okay? But in the 5% that are the ones we debate, the ones that we are talking about, stem cells, gun control, affirmative action, there is where you have to debate. So I participate in some of these cases. Let's take affirmative action. Well, the case was decided in an afternoon. Obvious there was a public audience before that. So I don't see it was a problem that some of the ministers took 2 or 3 hours to debate. I imagine how long it took to decide Brown versus Board of Education, probably months. Because it's made in public, you see all the idiosyncrasies of the debate. You see in the other cases you don't see. Even though I propose that Justice speaks only 20 minutes in each case, I agree that some cases are necessary that they speak more. And what the major question is that Supreme Court is doing too much. No, criminal cases should be taken out, other things should be taken out, and they could concentrate on constitutional law, where, you know, a lot of time is needed to have a good decision.
Thank you. Just for the benefit of the students there, I wanted Judge Peter Massetti to describe a little bit the process of deliberation among the judges, the justices here, because obviously they have they have clerks that are brilliant lawyers normally, and being a law clerk of a superior court, of a federal judges or Supreme Court justice is a very important thing. And how does it happen, Peter? Is there, what is it? Do the clerks talk to one another at some point? I know that there is every week or every 2 weeks the justices meet, right? Could you describe that process, how they reach their decisions internally?
Yeah. Each justice has a number of law clerks. I think it's 4 on the Supreme Court. And basically, you've got to remember, they've got almost total discretionary review. There's really no obligatory review in only some minor cases. So they can take as many cases as they want to. And they may get somewhere like 6,000 or 7,000 petitions a year, and they only decide 100 cases at the most. That's what they can do to control their docket. When a case comes up from a lower court, and usually it's when, for example, when there's a split opinion between the different circuit courts of appeal, and it's an important issue, that's the kind of case which the justices will decide to review. And at least 4 of the 9 justices have to agree to take review of the case before they will. That's called the rule of 4. Once the case is taken for review, the parties then file briefs. There may be other interested groups called amicus curiae groups that add in. But they file their briefs, and then when these briefs come in, what happens for the most part, I think now everybody is in the pool, but they have what's called a certiorari pool in the Supreme Court, where the justices will review the different cases that have come in, and they'll make a decision to accept review. When a case is accepted for review after it's briefed, it will be argued, and it's argued during a term. And in the same term that the case is argued, invariably it's decided in the same term, which is 1 year. And so there's argument, it usually goes until about May, and then from May to June, and then throughout the term, but the key decisions are usually issued in May and June of the year. The justices will convene, and the lead justice who wrote the opinion will simply announce their decision. And there would have been oral argument on the briefs some months before, open to the public. The justices don't talk to one another, they talk to the lawyers in terms of questioning. But then they write an opinion or opinions that are filed by the end of June of the same term.
Do they meet from time to time?
Oh yeah, no, they meet regularly. They meet to decide which cases will be accepted for review. They meet to decide how they're going to vote in the case. They meet to decide who is going to write the opinion, although that's usually up to the Chief Justice to decide. The Chief Justice, if he is in the majority, will designate the justice to write the opinion. If the Chief Justice is in the minority, he will designate our senior judge, our Celso Gemello, to designate who would write the opinion. And that's how it gets done.
Okay.
Paulo,
now,
from the São
yes.
Paulo side, we are running a little bit out of time. We have some other, so if we could come to a close, which I'm very sorry about it, because the conversation is being very
as
nice.
you know, the government here is closed. We have plenty
We have
of
a
time.
judge who has cases.
I think Judge Massetti would like to say something about judicial reform.
Yeah, if I may, this is very brief. I want to end on an up note and do some perspective. Constitution of Brazil, 1988, 25 years ago, right? So we're not talking about a long window here. You had a dictatorship of many years before that. Since that time, you've had a constitutional amendment that introduces discretionary review in the High Court, Constituição Geral, súmula vinculante, binding precedent. You've got something called Justiça Volante, where you send boats up the Amazon to take care of Social Security issues for Indians, or you send out fully outfitted buses to the interior to hear cases where a judge and a clerk are participating. You have small claims courts, which have become a victim of their own success that they're so used. And you have a huge movement underway right now in alternative dispute resolution, including arbitration. A datum that I got just 2 weeks ago at a seminar was this. 17 years ago, Brazil did not recognize international arbitration agreements. Today, Brazil is the third most active country in the world seeking review, seeking arbitration internationally. So when you talk about judicial reform, and I would disagree with the statistics in the Supremo, I think there's been a significant reduction in the caseload there because of súmula vinculante, binding precedent, because of repercussão geral, which is discretionary review. There has been movement, and Mensalão, in my opinion, is on track in the same direction. Is it perfect? No. Is there much to be done? Yes. Will it never be perfect? No. But there is a noticeable trajectory.
Well, with that, I would like to thank all friends present here, all friends present in São Paulo at the Fundação Getúlio Vargas. I think this is a wonderful collaboration. I hope this is the first of many. Fundação Getúlio Vargas Law School, or Direito FGV, Direito GV, as we call it, American University Washington College of Law. Special thanks to Oscar Vilhena, Dean of the Getúlio Vargas Law School, Judge Peter Massetti, Senior United States District Judge for the District of Maryland, and an adjunct professor at the school at the American University Washington College of Law. Matthew Taylor, Assistant Professor of the School of International Service at American University, and Federal Judge Marcelo Cavalli. I'm very grateful to you all. I am especially grateful to two people here, the assistant to the Brazil Institute program, Michael Darden, and our brilliant intern, Ana Carolina Cárdenas, who is very proud to say to everybody that she is from Campinas. And I am grateful to them. The glitch we had initially had nothing to do with the tremendous effort that Michael put to get us connected and on time. But you know, sometimes things that are out of control, and the United States government is still out of Michael's control. So we had that problem. Thank you very much. It was an honor to host this, and let's make this the first of many. Thank you, guys.
Okay,
Well,
Paulo, thank you very much. I would appreciate all of you. It was a pleasure. And also would like to thank from our side Otávio Dias, who put this together from the FGV point of view. And obviously, I wish it will be the first from several debates, which would be very interesting for all of us. Thank you.
Thank you.